Good afternoon and welcome to the Legal Hour with Bailey and Gallion. I'm here with Ian Croall today, and we are coming to you from the Legal Cafe in downtown Fort Worth, just across from the courthouse, where you're getting suds and solutions and coffee. It's a new venture down here where we have lawyers in attendance, and you can come in and have a cup of coffee and discuss your potential case with an attorney. Today, we're with Ian Croall, and he's going to be discussing with us Social Security and Social Security disability issues. It's a thorny issue, and Ian, what I have learned over the years about Social Security is someone finds themselves newly disabled, and they think, well, I'll just fill out the forms and I can turn this in myself. And my experience has been that after they've failed for about 2 years, they come see someone like you who instantly fixes it.
Pretty accurate statement. That's pretty much how it goes on occasion.
Well, let's talk about what is the criteria for a Social Security disability claim, and when should you start looking at filing it, and should you use an attorney first?
Well, it's a good question. Of course, you should always use an attorney first. It's better to get things right the first time than have to do it the third or fourth time. In order to be eligible for Social Security benefits, you have to have a severe impairment that's expected to result in your death, unfortunately, or expected to last for at least 12 months. Okay. So that does eliminate a lot of the short-term injuries that somebody might have, broken arms, broken legs, a pregnancy.
That would be more like a workers' comp kind of thing?
More of a workers' comp or a private short-term disability policy. For Social Security disability, it does need to be something that's going to last at least 12 months. It doesn't have to be something that's going to be lifelong, but it does have to extend for at least 12 months. And by severe impairment, they really mean any type of injury that prevents you from being able to work full-time, 5 days a week, 8 hours a day, or equivalent schedule. Social Security actually defines working as making approximately $1,550 per month. If you're able to make that, they consider you capable of working.
That's not a lot.
It's not a lot of money. It's actually gone up a little bit every year, and it does change, but that's where we're at in 2024.
Okay. And so what's the first thing you need to do? I mean, you say that it's intended for injuries that are going to last at least a year. I'm assuming you have to have some doctor's notes and things like that?
Yeah, of course. Medical treatment is vitally important to any claim for disability. We also need to establish an evidentiary record. You have to have treatment records, you have doctor visits. We want to show a consistency of complaints. You know, you're consistently going to the doctor with, say, a back injury or a knee injury or a hip injury, and also talking to your doctor about what it is that's bothering you. You know, I have a hard time standing, I have a hard time sitting, I have a hard time walking or lifting. Those are all things that are very useful when we're trying to prove your case to the Social Security Administration. In terms of when one should file, given the way that Social Security's backlog is now, it's important to file as soon as you think you have an injury that's going to keep you out of work for 12 months. Even if you're on the fence where you think it may not last that long, it's best to get the ball rolling, because the way the administration's operating now, you could be looking at a whole year before you even get that first decision whether you're approved or not.
And if I understand correctly, you're not running to the courthouse. This is a different kind of proceeding.
Right. So this is an administrative law proceeding. So initially you do file it with a government agency. You can do so without an attorney. However, there are deadlines and there's paperwork that needs to be filled out. So it's always better to have an attorney working on your side rather than try to navigate the system on your own. There are 3 levels at the Social Security Administration. There's the initial level, there's a reconsideration level, and then there's finally the hearing level where you do appear in front of an administrative law judge. At the initial level, I'd say about 80% of all claims are denied. It's not something where you get approved automatically, and that does take about 8 to 12 months. The second level, there's a little bit higher success rate, maybe 30% of cases can be approved there, but that level also takes about 6 to 8 months right now. And then you get the hearing level, where you do appear in front of an administrative law judge. At that level, I would always recommend that you have an attorney if you've made it that far without one. And the hearings itself are relatively informal. They're what are called non-adversarial hearings. There's no opposing counsel there, but it is up to your attorney to prove to the judge that you meet the criteria for disability and are thus eligible for benefits.
We are seeing this in virtually every area of the law these days. There are do-it-yourself forms. And folks who are out there Googling it, okay, it must be true because they found it on the internet. And what we're seeing across a lot of fields is that these forms employ words that you and I would use around the kitchen table any day of the week. And we think we're pretty good at reading, and think we understand the language. However, these are defined terms under the relevant statutes. And as defined terms, they have very special meanings that ordinary lay people are not going to appreciate. Consideration does not mean the same thing in contract law as it does sitting around the kitchen table. And so it is very, very difficult for anyone who's not trained in the field and familiar with the special hidden magic definitions that these terms have to accomplish much on their own. And that's why I was saying before, I've seen so many folks struggle for years, finally throw up their hands, and their attorney gets it fixed, and just lickety-split.
Right. Now, unfortunately, we do see a lot of that. In terms of the paperwork that Social Security requires an individual claimant to fill out, there are just things that you don't think about in the normal course of everyday life. You know, if you've been a truck driver for 30 years, you describe your job as I sit in a truck and I drive all day. And that's fine. That is what you do. But when we're trying to prove your case to Social Security, we need to show that there's other things that are involved there that you may not think of just off the top of your head. You know, you've got to check the tires. You've got to make sure the load's secure. In some circumstances, you've got to kind of get under the truck and do a pre-ride inspection. Those are all things that increase the physicality of that job that make it more likely to get approved for Social Security. But if you don't add that to the forms that they provide you, you're really hindering yourself and really not giving yourself the best chance at success right off the bat.
I see. Now, what's the difference between SSI and SSDI?
That is a very good question, and one I get quite often. So there are two programs that are available. SSI, or Social Security Insurance, is a need-based disability program. SSDI is the more traditional Social Security that workers pay into the system and get at retirement age. Essentially, when you collect SSDI disability, you are just getting your retirement benefits early because of your physical or mental disabilities.
Okay.
For SSI, if you have not had a consistent work history and have not paid into the system, you still have to have the same you still have to prove disability. However, you also have a secondary component where you have to demonstrate a financial need. And in order to demonstrate a financial need to be eligible for SSI, you have to have a family income of less than $2,000 for an individual or $3,000 for a couple. You also have to have
per month or year?
Per month.
Okay.
You have to have only one car in your name and only own one piece of property, and have less than $2,500 in the bank. If you have two cars or two pieces of property or more money than that in the bank, you're not going to be eligible for SSI disability, regardless of how injured or impaired you might be.
Okay. Well, let's say I'm receiving VA, workers' comp, or some other kind of disability. Can I still apply for Social Security?
Absolutely, you can. For veterans benefits, your VA rating and the money that you receive from the VA do not count towards your eligibility for SSDI. They have no impact on your eligibility for SSDI. You still work, you still paid into the system, and you can double dip and collect VA and Social Security disability benefits.
Okay, because they're different things.
They're different things, correct.
Can you work while you're applying for disability?
You can work while you apply for disability. However, there are limits to it. As I said, Social Security counts working making $1,550 a month for 2024. So if you were working under that amount, you are actually not working in the eyes of Social Security. However, the closer you get to that number, the more difficult it is for an attorney or yourself to prove that you can't get to that number.
I see.
So if you're really just working and making $1,500 a month, the administration's going to ask, why can't you do an extra 30 minutes or an extra hour or so to get that extra $50 a month across the board there? So it does have an impact on your eligibility, but it does not preclude you from accepting disability at those rates.
If you try to take a job and fail, is that going to hurt you?
It is not going to hurt you. In fact, as an attorney, I actually like those cases better. The administration has got a lot of programs in place to encourage people to work, which is, what ideally we want everybody to be capable physically and mentally of holding and sustaining work. However, it's just not always possible. So in order to encourage people to at least try, there are several programs Social Security employs. The first is a trial work period, where if you do suffer an injury or a mental impairment and you stop working for a period of not less than 30 days, you can try and go to work again while you're still applying for benefits. If you do not work for a period of 5 consecutive months, and that is called an unsuccessful work attempt, it won't break the chain of disability. It will make you have to start over.
Okay.
If after you've been out of work for a period of 1 year and you want to try to work again, they have what's called a trial work period. And this is available for people who are already on disability or are still waiting for a decision to come in, where they can actually try to work at any amount for up to 9 months. And they can be non-consecutive, where they can try to work and hold a job. And if they're not able to do so, then again, it doesn't interfere with their rights for a claim for disability.
What is SGA?
SGA is what is called sustained gainful activity, and that is what Social Security uses to define whether an individual is capable of working. And that SGA amount for 2024, like we said, is $15.50 a month.
Now, if I'm a truck driver and I'm injured and I can no longer perform the duties of a truck driver, am I required to find a new career?
That would depend on how old you are. So
okay.
Social Security kind of holds the old Adam, you can't teach an old dog new tricks, or at least a middle-aged dog new tricks. Okay. So as you get older at Social Security, the typical standard at Social Security for disability is you have to be found incapable of performing any job in the national economy 5 days a week, 8 hours a day, or equivalent schedule. After you cross third age threshold at 55 or 50, that standard does diminish quite a bit. So at the age of 55, if you've been a truck driver for 30 years and you no longer can drive a truck, they would have to find work that would transfer from truck driving to another field for you to be able to do that job. And it's very difficult from truck driving to go into a more sedentary occupation,
right,
like an office work or anything like that. So it does get easier, and you would not be expected to find a new field.
I'm thinking that there may be situations where you might be able to still do the type of job that you'd been doing, but you no longer qualify for the credentials that are required to be able to do that job.
That can be a little more difficult, depending on your age. Again, if you've still got the physical capabilities to perform the work, but maybe can't get you can't have the vision to get the driver's license, let's say, or a pilot's license to capacity. It would be up to the attorney to prove to the judge that what skills you have left would not transfer to other employment that you could do.
Okay. So generally speaking, and I know we're talking globally here, but generally speaking, how long does it take a Social Security claim for disability to work its way through the system?
Well, unfortunately, since COVID, we've had a lot of variation in that. Whereas initially, an initial application would get its first decision in 3 or 4 months. Second decision would take another 3 or 4 months. And then the wait for a judge would be approximately a year. So we were looking at about 18 to 24 months. What we're seeing now is almost a full year wait for that initial decision to come in, about an 8-month wait for that second decision to come in. But luckily, the hearings, with the advent of the video hearings and the phone hearings, judges have been more efficient, and the wait for a judge is down to about 5 months now. So it's still a 24 to 28 month wait, but it's a little more front loaded than it used to be, and it's a little quicker on the back end. So again, when you were asking earlier about when should you apply for disability, it's very important that if you are injured and you think it's something that's going to last 12 months or may even potentially last 12 months, it's important to at least contact an attorney to see if it's a good idea to get the ball rolling so that if the unexpected does happen, you're ready to go and you have your case already halfway through.
A lot of the courts today are trying to get away from Zoom because we were in it for so long. But are you saying that in your particular area, Zoom is still utilized quite a bit?
It's still used quite a bit. In fact, since COVID, there's about 3 methods of appearance now for Social Security hearings. There's the old-fashioned in-person, there is just straight phone hearings, and then there's a Microsoft Teams video component to it. At Bailey & Gallion, we use all 3. I'm comfortable using all 3. But I do think there's circumstances where an in-person hearing is certainly better. But I also think there are circumstances where a phone hearing is just fine as well. You know, certainly when you look at where people live and their physical capabilities to get places, a phone hearing can really be just as effective as a video or an in-person hearing if handled properly.
You're operating out of the Dallas office. Do you have very many clients who are scattered around the country?
We do cases all over the country. Prior to my actually coming to Bailey Gallion about 8 years ago, I have done hearings in all 50 states, including Puerto Rico. It's a federal program, so I only need to have 1 bar license. I do have 2, but I only need 1. And so it has allowed me to see the country a little bit. Each state's got its own intricacies a little bit. While it's a federal program, you know, there are still timeline differences in different states. Texas is one of the slowest, unfortunately, right now. It's one of the more difficult states to get an approval in, where some of the West Coast and Eastern states are moving a little faster and have a little bit higher success rate, at least initially. At the end of the day, the success comes down to your ability to show the judge that your injuries are precluding you from sustaining employment. And that could be something as simple as, I cannot stand for 6 hours, I cannot be on my feet for long periods of time, or I need to rest or recline frequently throughout the course of the day to kind of get the weight off your back or off your knees. And if you've got to take those breaks, it's very hard for individuals to maintain or sustain employment.
One thing we're seeing in a lot of areas, and I would guess it's particularly important in your area, is the impact that substance abuse or misuse can have on your case. In a lot of areas, in some states, some of it's legal. In other states, it's not. And I think what the data is indicating now is that it is much, much more prevalent than it was even a few years ago. What kind of impact is that going to have on you proving that you're disabled to Uncle Sam?
Well, it depends on the nature of your condition. Certainly for some mental health cases, and I'm talking about anxiety, depression, post-traumatic stress, or psychosis of any kind, substance abuse plays a big factor. It's very difficult for your attorney or for anybody really to convince the judge of how bad your depression is if you're having a drinking problem, let's say, because clearly that's having an impact on your condition. Right. The rule at Social Security is, but for the substance abuse, would you be found disabled? So, for example, if you've got a bad back and you have a couple drinks every night, you're still going to have a bad back. That's not helping your back. It's not causing your bad back, and that substance wouldn't have an impact on your case. Okay. Again, however, though, if you've got psychosis and you've got hallucinations, and you're coupling that with some psychedelic substances, it's very hard to separate which is causing which. And if the cause of your impairment is based on a substance abuse issue, then you will not be able to be found disabled. However, there are different ways to navigate that. It's also important to remember that if you're a smoker and you got lung cancer and you don't smoke anymore, you can still be found disabled for lung cancer. If you stop smoking that day, unfortunately, you're still going to have lung cancer, and that won't have an impact on your ability to claim Social Security. In the same way, cirrhosis of the liver and drinking can operate in that way too. But given the kind of world we live in now, where some states have things legal and some states do not, you kind of see a little bit variation even in Social Security on what is going to have an impact in a case and what will not. My rule of thumb is to always kind of approach those issues head on with the administration and the judge, and talk. There are a lot of people that use different substances for pain relief, and what we've seen in the last 3 or 4 years is a lot more acceptance of that. Do
you find there's a bunch of regional differences?
I do.
Hey, it's California.
You find a little bit of regional differences. You find a little bit of differences between judges. There's a generational thing, I think, on some of this too, where older judges are a little less likely to have more leeway, where younger judges may. And you see it the other way too. That's another reason why having an experienced attorney is important, because they can kind of let you know the tendencies of one judge versus another, and what things to highlight and what things to maybe focus on in a hearing.
Let's say that you're working this system, the process, to file your claim and work it through to the end. Do your dependents receive any benefits?
They will. So there are dependent benefits. If you've got minor children under the age of 18 and you are disabled and can't work, you will receive a boosted amount monthly to help cover the cost of the kids. And that's based on what you've inputted into the system over the last years while you were working, as well as how many kids you have.
All right. What about widows?
There are widows' benefits available. Now, widows' benefits are based on the spouse's work record when they were alive. In order to claim widow's benefits, you do have to be married to an individual for 10 years at least. Okay. That doesn't have to be traditional marriage with a certificate. It can be common law marriage. Obviously, there's another step to prove that, but it can be common law marriage as well. And you have to be at least over the age of 50. If you're over the age of 50 and your spouse is deceased and you were married for 10 years, I can prove that you're disabled and you'll be eligible for your spouse's benefits. Once you reach the age of 60, you're just eligible for those benefits. You don't even need an attorney like me.
Oh,
you just sign up and you can get it. It's really helpful for the housewives who have worked, to raise the children while the husband worked. Unfortunately, the husband passes away. This allows the spouses to get on benefits earlier than they typically would while they wait for their normal retirement age.
All right. So what if I'm already collecting early retirement? Can I apply?
You can. So this is a little known fact about Social Security is, like I said, Social Security essentially is just getting your full retirement benefits early because of an impairment. If you've chosen to select early retirement, you are taking a deduction in what your full retirement benefit would be. If we apply for disability and you are found disabled, you will receive the full amount and you'll receive compensation for the months where you were hit with that pre-retirement penalty, early retirement penalty, I should say.
My wife and I recently applied for Social Security because we hit that magic age.
Yeah.
And again, I bet you she went to 20 classes to try and figure out how to file the paperwork. And it wasn't for disability. It was just the paperwork that they told us we would, be incarcerated if we didn't file it timely and that sort of thing. Do you work very often with folks who are providing advice to people on how to do that?
We always encourage people to call us at the disability department, Billy Gang. We do provide advice on how to navigate the system. We try to let people know what's best for them on an individual basis. We take the time, we will talk to you, we'll walk you through your scenario. If it's something where you need an attorney, we'll certainly recommend that you hire one or you hire us. If it's not, we'll kind of give you the phone numbers and the places to contact to kind of walk through that process on your own. Ideally, what we just want is everybody to get what they're entitled to. I mean, Social Security, especially when you look at SSDI and retirement, this is your money that you've been paying in through all your working years, and it's really just your opportunity to get it back. And we want to help people do that as best we can.
We've talked about how important it is to have an attorney in this process. How much does it cost?
Well, the fees right now are changing. The current fee structure at Social Security is it's 25% of the past due benefits recovered. So if you've been out of work for 2 years and you were entitled to $1,500 a month for 24 months, I'm not good at math, but that's a certain sum of money. We'd be entitled to 25% of that initial lump sum payment that you'll get. We don't take anything from the future payments or current payments that you'll receive. And there is a cap of $7,200 total. So we'll never collect any more than $7,200. That figure is changing to $9,200 by the end of this year, but that's where it's at right now is $72,000. And of course, it's a contingent claim, so there's no fee if we're not successful in getting your case approved.
Okay. Well, what parting thoughts would you want to leave our listeners with?
Well, I've been doing Social Security benefits for about 18 years now, and I've been here through COVID and through the early parts of the 2000s. And the way that things have changed, it's more important now than ever to have an attorney help you. The stakes are just simply too high. The timelines for approvals are getting longer and longer and longer. It's harder to get in contact with local offices. It's harder to get the help that you need without an attorney. An attorney who knows what they're doing with an experienced staff. I can't promise that your case will move faster, but I can promise you it will move more efficiently. And there won't be things where you have to redo paperwork or suffer delays that can otherwise set you back. And with a process that's already taking between 18 and 24 months, if done perfectly, if it goes soup to nuts, you really don't want to be in a situation where you're 3-4 years out not collecting any money.
Right.
It's while you will get it all back in a lump sum, it's very difficult for people to overcome that initial loss for a long period of time like that.
Ian, tell folks how they can get in touch with you.
You can give us a call at the Dallas office is 214-252-9099. You can also look us up on the website. We have chat and a 24-hour call center for Bailey Guy.
And is there any charge for an interview?
Absolutely not. Like I said, we're happy to answer any questions about Social Security. We like to point people in the right direction. If it's something we can't help with, we like to give you at least the phone numbers or the contact information to help people that can help you. And if it's something that we think we can help, we will sign you up.
Well, thanks for being here with us today.
It was my pleasure.
I'm Keith Spencer. This is Ian Croall. We're with Bailey and Gallion, and we're coming to you today from the Legal Cafe, serving up solutions here on the corner of Main and First Street, just across from the courthouse in Fort Worth. Come by and have a cup of coffee and ask us any questions you have. Thank you.